Hi, I am Dr. Shovik Chatterjee, Assistant Professor, National Law University, Jodhpur. This module that I have prepared is in the context of overview of competition law enforcement in United States of America. If the law relating to competition law and also antitrust issues all across the country, they are tested in that context. The US law basically is considered to be very old law. The first acts as such, whether Sherman Act, whether Clayton Act, especially the Sherman Act had been enacted in 1890. So US has an edge in the context of a number of other jurisdictions all across the world. Reason being that in majority of the other countries the law is quite new. So there are not a lot of case references in that context where the discretion of the courts of law in the context of anti-competitive agreements, abuse of dominance, different types of mergers, they themselves had been tested. So US law basically is considered as one of the guiding principles in the context of the laws that are there in other jurisdictions. Now continuing with the acts in United States of America, the Sherman Act 1890, the Clayton Act 1914 and the Federal Trade Commission Act 1914, they were the major acts or the enactments which were enacted to address the formation of cartels, collusion, restraint of trade and other practices which were of anti-competitive nature. In the context of cartels, it has to be explained that they are basically those form of secret arrangements whereby companies themselves they create a collusion and thereafter either fix prices or allocate the respective markets, or in some of the cases they go for a collusive tendering or export restriction, whatever they basically do. But whatever activities they do in the parlance of the economists, they themselves are absolutely detrimental to the interest of the economy. So United States law in this context, in the context of the Sherman Act 1914, had been a very welcome step in the context of addressing cartels within the country, cartels outside the country. Now the Federal Trade Commission, that is FTC, and the United States Department of Justice, they are the main bodies which are given the task of enforcement of antitrust laws, and they adjudicate disputes relating to competition law within the United States. Now the US enforcement branch basically tackles cartels very strictly. Any contract or combination in the form of a trust or any conspiracy which basically is injurious to trade or commerce is prohibited under section 1 of the Sherman Act. Now very simply, people all across the world might be wondering why is that they have mentioned these types of laws as antitrust laws. In the context of United States, what is understandable is that in respect of the major business organizations, they basically do business in the form of a trust in favor of the respective business houses and in favor of the country. Now wherever they basically commit breach in those respective situations, they basically lead to huge amount of economic losses. So as a matter of fact, the legislations that had come up in the United States, they are considered antitrust laws in their respect, due to the fact that whenever these anti-competitive agreements take place or collusion takes place, they are in one form or the other an antitrust activity and thereafter anti-competitive in nature. Now in United States, certain forms of cartels like price fixing, they are considered illegal per se. United States basically considers two types of activities to be tested in the context of anti-competitive elements. One form of their respective yardstick is considered to be the per se illegality, whereas the other yardstick basically is in the form of rule of reason. Now as far as per se illegality is concerned, in the context of United States, they basically consider certain activities having more pernicious effect than the other respective activities. For those activities, what happens is these respective practices are considered to be bad at the very outset. So question of reviewing the pro-competitive benefits and also the anti-competitive benefits, that doesn't arise in the context of those certain activities. So what they have done is, instead of wasting the time of the judiciary in terms of finding out the the pro-competitive benefits and thereafter judging the respective activity based on both sides, they consider these activities to be per se bad, and if they are per se bad, then the question comes that the respective antitrust agency, that means the Federal Trade Commission, is only supposed to prove only the activity. So in the context of price fixing, they are considered illegal per se. By per se illegality, it is meant that there is no scope of rebutting the presumption that the act has pernicious effect on the economy. Sherman Act was enacted in 1890, and from that time onwards there had been plethora of cases where the respective activity in the context of price fixing had been addressed. United States versus Trenton Potteries Company Limited case, that is one of the cases which can be talked about in the context of price fixing. In this case, decided judgment of United States court, they require mention. Although I have talked about the respective pottery case as such, the other case which is very important includes Arizona versus Maricopa County Medical Society case. Here a number of foundations, they were established by the doctors to promote fee for service medicine and to promote the community with a competitive alternative to the existing health insurance plans. The foundations, they by agreements of their member doctors, they established the maximum fees the doctors could claim in full payment for health services provided to the policy holders of specified insurance plans. In most of the first world countries, health insurances, they are basically a must, and these health insurances are almost very similar to the different types of insurances that we basically take maybe in the third world countries like that of India, where the question in the context of paying premiums at regular intervals, that takes place, and when the respective fees are being paid whenever people get sick, then it's the job of the respective doctors and the respective clinical establishments to do the needful in the context of the treatment that has to be carried out. Now the state of Arizona, they basically alleged that they were engaged in an illegal price fixing conspiracy in violation of section 1 of the Sherman Act. The question before the United States Supreme Court was that whether there was violation of section 1 of the Sherman Act or not. There were agreements among the competing physicians who by majority vote they said the maximum fees they basically had fixed up, and that they could claim in full payment for health services provided to the policy holders of specified insurance plans. Now as the prices were fixed in that context, obviously those who are actually using the respective services, for them there were no choices, and the entire practice basically was alleged to be absolutely anti-competitive. The United States Supreme Court held that the fee agreements that disclosed in the record in the case among independent competent entrepreneurs, the doctors, they fitted squarely within the horizontal price fixing mold, and therefore it was per se violation of the Sherman Act. In this context, it has to be said that there are generally two types of activities in this context. If one includes the horizontal anti-competitive activities, the other includes the vertical anti-competitive activities. Generally speaking, horizontal anti-competitive activities, they take place within the same line of production. So there the companies, they themselves are direct competitors in the same line, whether it's the line of wholesalers or whether it's a chain of producers or whether it's a chain of retailers. So there the pernicious effect is even higher. Any agreement or oral understanding which tampers with price structures is engaged in an unlawful activity within the jurisdiction of United States. The fact that was in this case discarded was that the members of the price fixing group, they were in no position to control the market. Now the question relating to market control comes in the context of abuse of dominance. This was a very fit case in the context of anti-competitive activity. So the question of how much market control they had, how much dominance they had, was not put into question. But the fact which was given weightage was that they raised, they lowered, they stabilized the prices, and they had interfered with the free play of market forces. Now in this context, what has to be understood is that as majority of cartel cases, they themselves are very secretive in nature. Generally the respective antitrust agencies, they are supposed to actually also find out a plan whereby leniency is being provided to the respective parties who are alleged to be anti-competitive. For example, United States had developed a corporate leniency program that is an incentive to the cartelists to disclose the cartel. If you remember back when India was under a colonial rule under the British government, there was a time when the British government also promoted a system of approvers. The approvers were the persons who were part of the same respective freedom movement, and what they used to do was whoever actually was the approver was being given an incentive by the British government in case they gave evidence against the other fellow freedom fighters. In that case, their respective punishments, they were being waived. and so the relinquishment in the context of their respective punishment had given the incentive, and for that a number of so called freedom fighters, they actually acted as approvers. Same is the question in the context of this corporate leniency program that is there. In this context, what United States basically does is that they give incentive to the first informant. The origins of this policy require brief discussion. The antitrust division, they announced its first leniency policy, that was in October 4th, 1978. A revised leniency policy that was introduced because the previous program was not adding value. Here two factors are supposed to work out. One is the fact that when a person is being given an incentive, the person should understand that, or have a direct confidence in respect of the agency, that the moment they actually come down to the agency and let them know about their involvement in the cartel, the agency or the competition body is supposed to actually give them actual form of leniency or amnesty. That had happened with respect to United States. The second question is that the body which actually punishes them should also be a body which has the capability in terms of tracking down the cartels. In the context of United States, that question had also worked out. So a revised leniency policy was introduced because the previous program was not actually adding value. The new leniency program, they added a new and significant variation, that is leniency after the investigation has begun. Now to post the respective leniency to the respective antitrust agency, here is the Federal Trade Commission. A number of yardsticks are supposed to be met. In the United States context, 7 conditions are supposed to be met. Firstly, the company which comes first and discloses the existence of the cartel first, they are the only companies which are granted leniency. Secondly, the company has to approach the division before the division actually gathers adequate evidence. Thirdly, the company, the moment the cooperation and reporting before the division happens, commits in respect of ceasing and desisting the operation that it is alleged to commit. Unless the company actually ceases the activity, it is not possible on the part of the antitrust agency to grant any form of leniency. Fourthly, the company cooperates with the division in the fullest sense. Whatever report is expected from the division, the company provides for them, because the question is, the respective antitrust agency in the United States context is the Federal Trade Commission. They should be in a position to prove the respective cartels in the actual proceeding before the court of law, because as United States has criminal sanctions, always it's understood that in criminal cases are proved by proof beyond reasonable doubt. So wherever there is any scope of doubt that is there in the minds of the judges, it's more obvious that the respective doubt goes in favor of the alleged party or the accused. The respective doubt never goes in favor of the actual investigation agency. So here it is understood that the disclosure that has to be done on the part of the cartelist has to be done in favor of the so-called cartel, and thereafter establish the respective case beyond reasonable doubt in favor of the Federal Trade Commission. The entire confession also has to be a corporate confession. It cannot be individual confessions of the persons at personal level. And in its full capacity, the company has to pay for the losses suffered by the injured parties. In case the losses are not being paid, there are chances that the respective agency here, the FTC, may not allow the respective amnesty at the highest level. And also the division has to ascertain that the entire corporate leniency program does not create harm to the other companies, considering the nature of the illegal activity, the confessing company's role in it, and when the company comes forward. Now US Department of Justice basically had mentioned and given absolute details in the context of how the respective amnesty program works. The next question in the context of antitrust issues includes abuse of dominance. Well, in the United States, abuse of monopoly is strictly dealt with under the Sherman Act, and there had been a sea change in the context of how dominance is perceived all across the world. It's not only a question of United States, but many other jurisdictions all across the world. They basically these days only frown upon abuse of dominance as opposed to dominance at one point of time. There was a time 100 years back when economists used to feel any form of dominance where 2 or 3 respective firms had absolute dominance. Those were the cases where they had basically actually disturbed or harmed the existing economy and the affairs of the smaller players in the business. So any form of so-called monopoly or any form of dominance used to be always frowned upon by the respective organizations and antitrust agencies. Even in the context of India, the Monopolies and Restricted Trade Practices Act actually used to look upon monopolies as to be some of the respective practices which were harmful. Now there had been a sea change in respect of how the countries all across the world, the different jurisdictions, actually did look in the context of abuse of dominance. These days what they understand is dominance is not bad per se. Any form of abuse that takes place, they are basically frowned upon. According to this United States law, every person who shall monopolize or attempt to monopolize any part of trade or commerce amongst several states, they commit an offense. The courts in the United States, though through case references, they had established the law for the time in force that monopoly is not per se bad, but the manner in which it is obtained determines the lawful or unlawful dimension. That is section 2 of the Sherman Act as such. Now predatory pricing is one of the forms of the prohibited conduct. Now we understand ourselves always the predator, even in a question of a jungle or a respective river, are the respective animal or the existing human being or the so called company which actually has the power of eating up the smaller players. Now to prove predatory pricing, the plaintiff must show that the developments in the respective market had interests prejudicial to the interest of the predator, and that prices are much below the cost prices of the competitors in the same market. Thirdly speaking, the competitor had an anticipation that through the desired scheme there will be an opportunity in future to restore the losses suffered by selling the products or commodities at below cost prices. Now if these things actually happen, then the question of establishing predatory pricing beyond reasonable doubt, it happens. In reality, according to the interpretation of many jurisdictions, the predator undergoes temporary losses for broad gains in future for a long respective period. Well, in this context it has to be understood that generally speaking, recoupment is also supposed to be established on the part of the Federal Trade Commission or any antitrust agency to prove that the predator really had affected the business of all the other respective smaller players in the same market. There are a lot of plethora of decisions in the United States, like Brook Group Limited versus Williamson Tobacco Corporation. Edgeworth Francis, the peer, had mentioned that in the peer theory of monopoly sometime back in the respective literature. Now in the context of determination of abuse of dominance, the determination of relevant market, that requires emphasis in the United States. The DuPont case gave adequate reference of a cellophane paradox in the context of this determination of relevant market. Generally speaking, we understand that relevant market consists of two forms of market. If one form includes relevant geographic market, the other form includes relevant product market. The geographic market basically includes the geographical dimensions within which the goods or services they are being provided. So if the antitrust respective activity had taken place, it is supposed to take place within that particular market. In the context of relevant product market, it is the question of test of substitutability, which is the respective product which if substituted will basically change the so called demand of the respective group of persons towards that particular product or service. Now where dominance entity which already had the ability of acting independently of the market forces has set up a price very high, there may not be availability of goods as absolute substitutes within that price range, which could lead to an inference about unconcentrated market and lack of dominance. Now on the other hand, if a competitive price were charged, it could lead to lowering of prices, decrease of substitutes, and increase of market share and creation of dominance. Now in this context, that is the test that is being taken out in the context of United States. The third part, which is probably the most complicated part in the dimension of antitrust activities, includes the mergers. Now mergers or acquisitions or amalgamations, all of them, they are very complicated, and generally it has been seen that companies, they do merge together to actually gain dominance in the respective market and also create know-hows and also sometimes increase in the overall market share. Now the Hart-Scott-Rodino Antitrust Improvements Act, they basically outline the laws in the United States in the context of merger review. Large companies having huge market share in the relevant market attempting to merge, they are first required to notify before the Federal Trade Commission and the US Department of Justice's Antitrust Division that they have actually involved in the merger. Now the thing is that in United States the reporting relating to merger should be done before the FTC within 30 days of notifying the combination. There are a number of books which basically had written on that, and the basic reason why it's being required to do so is for the fact that there has to be a so-called merger review. So the whatever are the pro-competitive benefits and the anti-competitive effects in the context of that merger, that has to be tested in the context of those existing mergers. Now the agencies use the Hufindel-Hirschman Index HHI, which is the sum of squares of the market shares of all market participants as the measure of market concentration. Now HHI, as the name mentions, Hufindel and Hirschman, both of them were big scientists who devised this respective system, and according to that system there are two ways by which the HHI can be successfully used for merger review. One group of economists, they basically feel that the optimum value of 0.18 can be fixed to be the yardstick beyond which the market can be extremely concentrated. The other section of the economists, they feel that the change in the value of HHI better tells the effect than the optimum value. That is, the question, if the respective HHI difference is higher, it shows that the market now had become concentrated, and thereafter any two companies being allowed to merge in that respective market is generally hazardous for the interest of the other companies. So section 1.51 sets out zones defined by the HHI and the change in the HHI within which mergers ordinarily will not require additional analysis. Proposed mergers ordinarily require no further analysis if firstly the post merger HHI is under 1000, secondly the post merger HHI has fallen between 1000 and 1800, and the change in the HHI is less than 100, or the post merger HHI is above 1800 and the change in the HHI is less than 50. Now in this context it has to be mentioned that the European Union, they actually give more emphasis in the context of the change of the HHI as opposed to the overall HHI value at the time when the respective merging companies, they have combined together. There are a lot of jurisdictions across the world who don't give that amount of heed in the context of the HHI value. For example, in India there is no requirement on the part of the Competition Commission of India to actually refer to the HHI when they actually go for the respective merger analysis. In this context it has to be now explained as to what happens in the context of the different jurisdictions in respect of the mergers. Well, as far as mergers are concerned, it has to be understood that the number of days before which the respective companies are supposed to let the competition agencies know or the antitrust agencies know that they have combined together, they are generally very relative and very different across the jurisdictions. United States has 30 days, and that is a very optimum period in respect of the companies to come before the Federal Trade Commission and let them know that they have merged together. Now in the context of the respective agencies, the biggest two agencies in the United States who actually looks into antitrust activities includes the Federal Trade Commission and the US Department of Justice. As far as the Federal Trade Commission is concerned, it was created in 1914. Initially the job of the FTC, they was to take care of anti-competitive activities within the country, because it was not understood in those respective days that these respective anti-competitive mergers or abuse of dominant position could have international or cross-border dimension, which later happened as a matter of fact in the last 10 to 20 years as such. Every commercial activity in the country was in the form of a trust, and activities which were ended in restraint of trade, they were designated to be antitrust. Now in 1938 Congress passed a broad prohibition against unfair and deceptive acts and practices. A number of other legislations, they were passed in the United States over a period of time, and the effects doctrine were given more emphasis so that the FTC could address antitrust issues occurring in other parts of the world but having effect in the United States. It has to be explained in this context that as far as the other countries all across the world are concerned, generally they don't give heed to the existing decisions of US Department of Justice, or the respective power is being given on the part of the antitrust agency over there, that is the Federal Trade Commission, unless the FX doctrine is in place. So, United States, in respect of a number of cases, through case decisions, they created a law whereby it is immaterial as to which part of the world the respective activity had taken place in the context of an anti-competitive activity. But the thing is that if the effect is being felt in United States, in that case both the Federal Trade Commission has the power in terms of investigating, and also the US Department of Justice has the power in terms of taking up the proceedings and conducting the so called trials. It has to be understood that it was created in 1840 and was established for enforcement of the law and administration of justice. Now, very significantly enough, US has a different system where the so called Department of Justice also plays a very important role in the context of what the Federal Trade Commission is supposed to work on as such. Now, generally speaking, in adversarial systems all across the world, the system is that the role of the judges are nothing better than that of the umpires as such. So, the judges, they never so called interfere in respect of what the investigating agencies actually commit. Their job generally is to weigh the evidence on both sides. So, when the investigation is going on, there is no scope on the part of the so called judges in terms of instructing or guiding the so called investigating agencies for carrying out the different investigations. Now, as far as the US Department of Justice is concerned, United States is a very developed organization. So, for that there had been advices being given in the context of how the FTC should go to different jurisdictions of the world, carry with them all the different so called gazettes concerned, and thereafter succeed in the context of how to actually do the investigation and thereafter bring the different forms of evidence so that they can succeed in the context of the so called antitrust enforcement, and also prove beyond reasonable doubt in respect of the antitrust so called cases. In this context, it has to be mentioned the head of the antitrust division is as an assistant attorney general for antitrust appointed by the President of the United States. The current AAG is William Baer, whom the US Senate confirmed on December 30th, 2012 in the context of his existing role that he is playing. Now, in conclusion, it can be said that the history relating to working of the FTC and the US Department of Justice, they suggest that the US enforcement agency has been very efficient to tackle cartels, abuse of dominance and anti-competitive mergers over the years. US had provided criminal sanctions, and the enforcement mechanism had been adequate to create deterrent effect on the big corporations. In the context of the successful cases concerned, the vitamins cartel case, the lysine cartel case, they were some of the cases where the US had also used their extraterritorial jurisdiction, that means the so called FX doctrine, and that had helped to bring in so called corporations outside United States back to United States, and the so called judgment had been passed whereby they had been fruitfully being able to establish the so called guilt beyond reasonable doubt, and also create deterrent effect in respect of both imprisonment and fines being asked to be paid on the part of the so called alleged parties. The FX doctrine in the United States had allowed the enforcement branch to implement the provisions of the antitrust laws in cross-border jurisdictions. The corporate leniency policy or the amnesty program had been very successful. Other jurisdictions, they should actually learn from United States how to really create a so-called deterrent effect through the enforcement of antitrust laws in their own so-called countries. As far as the books are concerned, there are a lot of books which basically deal with United States law and also some of the antitrust laws all across the world. One includes Perry's Rudolph's book. It's called Competition Policy in America, History, and it's basically the first edition was being so-called published in 2000. It's an Oxford University Press publication. There is a book by Smith Martin in respect of competition law enforcement and procedure. Butterworth's publication 2001. There is Johan Elner's book in the context of global competition law and economics. The first edition was published by Hart Publishers in 2007. There is a book by Graham Cosco, that is Competition Regulation and the New Economy. The first edition was published in 2004, and there is also Dr. Shovik Chatterjee's book on competition law in India and cartels in India and United States. The first edition was published in 2014 and the publishers were Allahabad Law Agency, India. So in a nutshell, it has to be said that US law basically they are also in the form of a transition, and they themselves are required to also look into international practices across to develop their own law. Other jurisdictions who are new, they can learn from United States and they reform their own so-called law. Thanks.